Tinubu no one contest with anybody at all. We did the plan election. This man they plan coronation. They want the register NDC. Peter Obi party there. No wonder he has been so calm. President Tinubu has been so calm since. I got the wonder all this ginger, even protest, way very dark man do. This man no fear. I don't know saying not the plan election. He not the plan to conduct any election. The register or the party. May they get out. He know the plan to do any election. See, they say they want the register. Say no way, no need to see NDC. From ADC, he don't come out. You know, say they don't plan the ADC, the registration. But they can't tell us, say, ADC, sir, Peter Obi no dey ADC again. You say, what do you mean? He said, the man no dey ADC again. He don't come out. He be like, he find waiting with the plan. He left. He said, then find him in the party he is. They tell us in the NDC, they register them. Guy, you know they plan the election. Now the registration, PM, they register all the opposition parties. Then he come that day, they will come call cabinet. Coroneta, Igwe, you stop planning to conduct an election. Can you imagine the strategy? You want to cripple the whole opposition. So Nigeria go to answer to you. Senate go to answer to you. Anything where you do, they go tell you say yes sir. Once you do it, they tell you say on your mandate we shall stand. Now what do you just want to do? Eh? But you no go work. You see this result and this it will not work. You find out late. He no go work. Come 2027. People don't ready. People are ready. Una don't try by trying to not give people their PVC. Una don't plan and finish. Una no go give the people their PVC, but you no go work. People go. You see all the plan, guy. You see the plan where person they use. Something the time where you for use this time. Take work for Nigerians. Use the money work for Nigerians. Use them. They plan one kurukere movement for coronation. Igwe. Mama Mia.
Because according to them, which is false, our logo looked like that of the APC. So we took INEC to court. While in court, INEC filed a defense, and in their defense, for the first time, they raised the issue of PMP, saying that our logo looked like that of PMP. In our response to that statement, we said, first and foremost, there are 18 political parties as at that time registered in Nigeria, and none of them is PMP. None of them has any logo that looks like ours. Secondly, out of the 171 political associations that registered seeking registration, none of them is PMP. So there was no basis for you to say that our logo looked like that of any other political party when there was none, either that has applied for registration or that was registered as a political party in Nigeria as at the time we were in consideration. During hearing, the judge asked INEC, PMP, is it a registered political party? INEC said no. Amongst the 171 associations that applied for registration, is PMP one of them? The INEC said no. So why are you bringing up the issue of PMP at this point? It was not the reason you refused to register us, and it was not the reason we came to court. The court, in its well-considered judgment, overruled every argument of INEC, including the issue of PMP that had no basis at all, and registered us. Now, as a lawyer, you are also a lawyer, you know. First and foremost, there are only two grounds, basically in law, by which you can set aside a judgment. One is that the judgment in itself is a nullity ab initio. Secondly, that your judgment was obtained by fraud. None of this applies in this case. Secondly, when a party feels that its interest is affected by any judgment of any court, what it will do is to apply, after judgment has been given, is to apply to appeal against that judgment as an interested party. And legally speaking, every rules or procedure of courts, there are time limits for appeal and for you to apply to appeal as an interested party. As far back as December 10 last year, judgment was delivered in this matter. It was common knowledge in the whole country that a court judgment has been issued ordering that NDC be registered from December 10 when that judgment was given till today. You can check when PMP purportedly filed their application. You don't set aside a judgment, a duly considered judgment that was given on its merits.
Finalized
In that same court. Enforced. The only defendant in that judgment was INEC. And INEC looked at the matter and decided that there was no basis for an appeal.
But look at what the court has said today. The court held that material facts were not disclosed during the
What were the material facts?
What were the material facts?
That's the question you asked the court.
The question the court is asking is that the ruling specifically cited non-disclosure of material facts.
What are the material facts?
You should ask your facts.
No.
Because the court said you are
If the court had said the material facts were hidden, the court will state what the material facts are. First and foremost, we argued in court that the party that came to court, the Peace Mass Movement, is not a known registered body. It's not a political party. It's not a registered association known to law. They claim to have applied for registration with INEC in 2015. And that INEC refused to register them in 2015, 9 years ago, and they went to sleep.
Do you suspect any foul play here?
Of course, every Nigerian knows that there's a foul play. Recently shown, a court in Nigeria ordered some parties to be deregistered. We are still talking about that. Another court that has given a final judgment that is subject only to an appeal is now turning around to give you a ruling. You are setting aside a judgment that is not a nullity, that was not obtained by fraud, by virtue of a ruling for an order to set aside.
But can the court by itself set aside its own ruling?
I don't want to say it's kindergarten law, that a court cannot do that. Everybody knows that a court cannot do that. The question is, why will a court, particularly a judge of that age at the bench,
procedurally,
in fact, to even hear the matter?
Procedurally, which court has the power to revert itself?
At this stage, and
I've told you, for the knowledge
every judge, every court
has
the right to set aside its own judgment on two conditions only.
If they found out?
One, if they found out that if the court had no jurisdiction in the first place to give the judgment, where the judgment is said to be a nullity. In that case, the court can, on proper application, set aside its judgment. The other case is where the judgment was obtained by fraud. Then the party applied.
Hiding material facts is not part of the principle that will allow a court to...
And then even at that, it is only the defendant in the matter that can bring an application to set aside. In a situation where material fact was hidden, the party must first of all apply for leave to appeal, not to set aside. The procedure does not provide for where anybody can jump out from anywhere and come.
Did your legal team underestimate the implications of this? Because the fundamental issue that INEC was presenting to the court was that you cannot register your party because of identity clash. And if the court now says, go back to the very beginning of this argument, does that mean one thing? When INEC said, I cannot register, and the court said, let's begin this trial.
In the substantive proceedings, admitted first and foremost that our logo did not resemble that of APC. That was the first thing they admitted to. Then secondly...
That's in the trial.
In the trial. They admitted, in fact, they didn't raise it. The moment we filed our suit, they didn't mention INEC logo anymore. They didn't mention APC logo anymore because they admitted during the proceedings that actually, in fact and in truth, our logo, the logo of the NDC, which is a two-finger victory sign, did not in any way resemble that of the APC, they now introduced the issue of Peace Mass Movement and admitted further that Peace Mass Movement is not a registered political party. It's not one of the 171 political associations that applied for registration. So there was no basis.
So fundamentally, what the court has said is that go back to the beginning of this matter.
The court had no right to do so.
I'm telling,
as a matter of fact,
just a moment, I'm trying to break it down for our viewers to understand, so that they will know what the implications are. The court simply said, go back and start this matter all over again. That's right.
Sean, you're a lawyer.
Yeah.
First and foremost, no judge has the right or the power to rehear a case it has had to conclusion. The principle of law is that at that point, the judge is functus officio. It has no right anymore to reopen the matter. In the first, I think it's very wrong for the judge to even have agreed to hear the matter from the very beginning. Because the moment the application was made, the judge ought to have known that not having the power to reopen the case, it cannot take any application on it. The only option that was open to PMP is that they could have applied to appeal that judgment, as an interested party.
So, but let's look at it. Political associations are regulated by INEC. And in that sense, there are those who will argue that your party should have just gone ahead and meet the requirement as being stated by INEC. Go and amend your logo because there is a look-alike, there is a clash of identity. And there are those who will now say, why is NDC wanting to use the court to bypass INEC registration process, attempting to achieve through the court what it could not obtain administratively?
Brother, let me tell you something. I'll ask you one question. 171 political associations applied for registration. Only one was registered. Do you actually believe that the rest 170 associations did not meet the threshold of the requirements of law? The truth is that that particular INEC had made up its mind not to register anybody. Our process started since 2017. We had met all everything, everybody that. In fact, INEC in the proceedings in Sosani trial admitted before the court that we had met all the requirements for registration. What you're saying is what some third parties who were not there, who do not know the facts of our case, have been saying in public, and we have tried severally to say this is not true. We didn't go to court because we are not qualified. But if we were not qualified, the court would not have registered us or ordered our registration. We went to court because we have met every condition for registration. But INEC whimsically decided they would not register us on the flimsy and excuse that our logo resembled that of APC. And you and I know.
Mr. Morgan,
yes.
Is this a setback for your party?
Naturally, it could be considered a setback. But the truth of the matter is that, like I said, we are continuing with our activities. We are put together a team to appeal against it, and we are confident that nothing would happen to us.
What if the fresh hearing now goes against you?
We're not going to go through a fresh hearing.
That's what the court said. That's what the court says.
See, elementary law shows that the court had no right in the first place to make that order. The court had no right even in the first place to hear that application. So how can you cannot place anything on nothing and expect it to stand?
Your presidential candidate is of the opinion that this is in part about him, and that there is an effort to ensure that he's not on the ballot. Do you think so?
Every Nigerian that is old enough to understand things know that there are people who do not want the democratic space to be expanded so there can be a proper contestation for positions in the next general election. Every Nigerian knows that what is happening in the political space today is predetermined by certain persons that do not want proper contest. You don't need anybody to tell you that. Peter Gregory Obi, who is our presidential candidate, is the choice of a gross majority of Nigerian people to assume the mantle of leadership of this country come 2027. And some persons who know they do not stand a chance against him in the elections do not want him to be on the ballot. That's what this is all about, and that's the reality.
And you don't think this could happen in 2027?
It will not happen. I can assure you that it will not happen.
But is the NDC ready for a long legal battle? And this is my fear, considering legal timelines in this country. It does look like you're running against time.
We have 6 months or thereabout to the next general elections in January and February next year. So, see, let me tell you something. There's a funny thing about this matter. We were scheduled to pick up our codes to start uploading our candidates today. In fact, we were at INEC yesterday. We were supposed to be at INEC today to pick up the codes. And then at the middle of the day today, this ruling just comes up. I think it was designed and timed to stop us from picking up those codes. But I can assure you that we'll pick them up. We'll pick them up, we'll upload our candidates, we'll participate in the elections, and I can tell you now, and I can also tell our supporters, our members, and our candidates, they have nothing to fear. All our candidates will be on the ballot come 2027, and we'll win the elections, because Nigerians are fed up with what is going on in this country today. We are fed up with the hunger, the insecurity, the failures of government, the heartlessness of the government that is ruining this country today, not ruling this country. And all their efforts to ensure that credible candidates like the candidates we have as our candidates contesting the election because of their fear of a defeat. And it will happen. It will come to them.
The motion on notice when the PNP joined in this matter, was it started on the NDC?
Yes, it was. The PNP did not join. The right thing for them to have done, like I said, repeatedly, if a party felt that a judgment affected it and it needs to appeal, not set aside the judgment, because it cannot set it aside, legally speaking. I'm old enough as a lawyer to know that you cannot set it aside. What they could have done is to bring an application before the same court that gave the judgment, seeking leave to appeal as an interested party. Normally, they would need to file their own notice of appeal and grants of appeal, showing that they have a substantial case to argue at the Court of Appeal. And the court can decide to grant them leave or not. That's the only application a judge who has given judgment the matter can hear.
I know that just before now, you were at your party's press conference, and the national chairman of your party was speaking there. And these are some of the images coming from that press conference earlier today in Abuja. Let me allow you to have a listen to some of what was said at that press conference. Take a listen.
There was no order directing our deregistration. However, we are dissatisfied with the decision that has been made, and we have instructed our team of lawyers to immediately proceed to the Court of Appeal to challenge the jurisdiction and propriety of His Lordship's order. We assure the general public, and particularly our candidates at all levels, that our party is on course. The NDC has not been deregistered. And we are challenging today's order at the Court of Appeal as soon as possible. We have no doubt that justice will be done.
As the national chairman of the NDC earlier today, finally speaking, this is somewhat a setback, and a lot of people will think, if we vote NDC, it's going to be a wasted vote. Don't you think that the lethargy can come into the heart of your supporters?
You see, what they are trying to do will backfire against them.
What is it? Who are they?
We all know who they are. I don't need to mention their names.
No, I don't know. I'm asking.
No, I'm saying that we
don't mention there are probably those
what I'm saying
who don't know. Who are they
are trying to make us more popular, more acceptable, because Nigerians will naturally rise up against tyranny. They'll naturally rise up against what the government of the day is trying to do. It's unfortunate that the judiciary is lending itself to this kind of absurdity. It's very unfortunate. But I tell you that Nigerians who are peace-loving, but Nigerians hate tyranny in all its forms. And what is going on today is not in the best interest of our democracy. It's not in the best interest of this country. And I'm sure even the international community will be looking at what is going on, and they will be shaking their heads in disbelief. I call upon all Nigerians who have any modicum of, should I say, good faith in this country to rise up and say no to what is going on. It's not, if it's NDC, it was ADC and other parties yesterday. NDC came out to say, no, it is wrong. You cannot order parties to be deregistered. Today, they are carrying the battle to NDC because they know that as of today, NDC is the actual, real opposition party in this country. And they want to stop us. They cannot.
Ikena Enekwizu is the National Secretary of the NDC. Many thanks, Mr. Morgan, for joining us tonight.
Thank you very much.
I appreciate it.